welcome to the PUCL public meeting on judicial accountability. Gayatri is a noted human rights lawyer and senior advocate of the Bombay High Court and a member of People's Unit for Civil Liberties from the Maharashtra unit. She is one amongst us and has played a very important role in litigation advocacy in courts. She's taken several human rights issues to the courts and procured orders for victims and justice seekers.
Just to put it in a context, and particularly since the bail application of Teesta has been rejected today by the magistrate in Ahmedabad, if we look at that order of the bail order which was passed, the judge basically takes over from the Supreme Court judgment certain observations made by the Supreme Court with regard to what he called others without naming Teesta. And in that judgment, basically the Supreme Court said that as far as Zakia Jafri is concerned, the wife of Jafri, who was brutally murdered to death along with 68 others of Gulbarga society. The judge, Justice Khanwilkar, says that she was basically emotionally manipulated by Teesta and others. One. Two, because of this emotional blackmail or manipulation, she was used in this whole process, and during this entire period of 16 years, where Jafri as well as Teesta and others fought from the time when the matter came up in court against the accused in the case of the victims being killed in the Gujarat riots. And the basic question, basic issue or relief that they were seeking was that please reopen the investigation. You have illegally closed the investigation. You have not considered the evidence of various witnesses. You have not considered various documents that were produced. And the SIT report, which was submitted before the court, which was accepted by the court, and a closure report was submitted. That closure report is illegal and it should be reopened. And in that context, a protest petition was filed by Jafri and Teesta. By Jafri, basically. The court says, no, you have fought for 16 years. And during this period of time, you kept the pot boiling. You kept the pot boiling in order to accuse and to cast aspersions on the Chief Minister and on the various higher level politicians and police authorities. This is an audacity that was committed by you and others, that is Teesta, and that audacity to question the officials will not be tolerated. The second part of that judgment, which is used, and the reason why I am saying this is, which I am sure the speakers are going to cover that, but the reason I am saying this is because in exact those words, the magistrate has taken in the observations made by the Supreme Court. So the second issue was that you people sat in air-conditioned rooms and fabricated documents. You fabricated documents, you sat and wrote down, provided affidavits which contained false evidence, and this has caused great injury to the PM and various other political officials. Third, that because of this false implication, because of this false documentation, you must be put in the dock. Just imagine the terms that a Supreme Court judge is saying, where a Supreme Court judge has absolutely no authority to cast aspersion on a petitioner without any proof, without any evidence, and there is a total inversion of the rule of law, where the court says, now you register a case against these people because they have committed an offence which has not been proved, and because they need to be put in the dock, and since they have abused the due process of law and they must be prosecuted according to law. Thank God for the words according to law. So here are these three major observations. There are many other observations which I need not go into, but these three major observations which have been used in the FIR which was filed against Teesta, in which the exact words from the Supreme Court judgment were reproduced in the FIR. And to make it worse, the magistrate reproduces the same observations from the court, from the judgment. The argument of the advocate on behalf of Teesta was that this is a fresh investigation. How is it that you have imposed so and so section 191, 192, 193, 194? All these are sections which are bailable and where the punishment is less than 7 years. Is she not entitled to bail? The court says no. This is not a fresh investigation. This is an investigation that is being conducted as a continuous investigation of the earlier case. Which is that earlier case? The complaint that was filed by Zakia Jafri, which was in 2006, which was the issue before the court. That issue was closed because the Supreme Court came up with the decision that is the petition is dismissed. So it's closed. The SIT was also disbanded because ultimately the SIT submitted a report in 2011 and that was the end of the matter. How is it that a fresh matter is being treated as a continuous investigation? That is the second issue. The third issue is that she is a danger to society because she has gone to the press, she has gone to international organizations, she has gone to various authorities where she has registered a complaint. Therefore, she is going to tamper with evidence and therefore she cannot be released. Now, I don't want to go too much into detail, but basically today's meeting is on the dangerous path that the Supreme Court is taking vis-a-vis activists, vis-a-vis organizations that are supposed to be supporting people who cannot come to court. I mean, this is what the Supreme Court told us many years back, that individuals who cannot come to court, organizations on their behalf can file petitions and come to court. I think everybody knows, more so our senior advocates here, that Article 32, which says you have a right to come to the Supreme Court for enforcement of your rights. Article 226, which says you can come to the High Court for enforcement of your rights. Today we are being told that, okay, yes, you have these rights. This is in the Constitution, it cannot be denied. But once you come to court, there is absolutely no guarantee that your freedom will be protected. I mean, this is the message that the court is giving out. The second, and I think they will deal with this Himanshu's case, where Himanshu was a person who was working for the tribals in Chhattisgarh. We know the situation in Chhattisgarh where the Adivasis are being brutally killed, are being brutally tortured because their natural assets are being taken over by corporate companies who are coming in, taking over the land and evicting Adivasis. Chhattisgarh is also the state which has the maximum number of under trials, Adivasi under trials. And here is a person who has come to help the Adivasis. He is the one who registered the case in the case of 19 Adivasis who were killed, brutally killed by the security forces and the armed forces in Chhattisgarh. So the question is that if a person comes forward to help people or files a petition, which was done in Himanshu's case, the court says that no, you cannot come to court because you are actually instigating the tribals. You are a person who is actually a Maoist sympathizer, and you have filed petitions in order to obstruct justice being done in that area and also to create an impediment in the work of the security forces. This is words in Himanshu's case, which is being used by the Supreme Court. Supreme Court does not look into the documents that have been filed, the FIRs that were not followed up with, investigation was not done properly. It does not go into all these aspects. It only considers the statements made by the police and the security officer on affidavit. So finally, the order in Himanshu is that you have made false statements, false affidavits have been filed, therefore you will be punished for this offence, and 5 lakhs was imposed as exemplary cost on Himanshu. That was not all. The Union of India, and I'll stop, I know I'm taking more time. Union of India filed an affidavit, filed an application saying that now, in view of the fact that false evidence has been produced, which again is not proved, false evidence has been produced, therefore, he should be punished under section 191, 192, which basically says false evidence being given in court, and 2, he should be, if one is not given, the second one should be given, which is that the CIA, CBI, the NIA or any central agency should have the right to file a case against Himanshu because he has implicated senior security officers with the intention to cause them harm. So on that basis, the order is passed, and we are absolutely sure that someday something will happen to Himanshu also, as has happened to Teesta. I would just like to, and that is the importance of today's meeting, and I think everyone should now, I mean, we are told that the police are there, etc., but I think this is the time when we need to speak up, and unless we speak up as citizens, tomorrow it is them, today it will be us, and then there will be, as